The proliferation of video is changing how Americans fight for their civil rights, and much of it is happening right here on YouTube. I'm Kim Norberg of the nonprofit civil liberties law firm, the Institute for Justice, together with co-host Keith Neely and IJ senior attorney, Patrick Jaicomo. Today, we're talking with special guest John Bryan, better known as the civil rights lawyer. John knows firsthand how difficult civil rights lawsuits have become, and he previously partnered with IJ to overcome one of the many immunity doctrines that make it nearly impossible for ordinary people to vindicate their rights in court. As IJ unravels that web of government immunity, John has successfully turned to video to hold abusive officials accountable. He and IJ use different but complementary approaches to reach the same goals, bringing justice to victims and creating broader legal change. This is Beyond the Brief. So John, the civil rights lawyer, welcome. And could you just kind of introduce yourself, give us a quick overview of how you first found out about IJ?
Well, thanks for having me. My name's John Bryan, and I just turned 44 yesterday.
Happy birthday.
Thank you. I was born in Charlotte, North Carolina, grew up in Florida. I went to undergrad at University of Central Florida, where I got a political science degree, and then I went to law school at UNC Chapel Hill. I did an internship with the Department of Justice long enough to realize that I didn't like commuting in this area around DC, and ended up just moving to rural West Virginia. And I've lived there and practiced law there for 19 years, almost, I believe now. But my original internship that I did with the DOJ, that was with the Civil Rights Division, police misconduct specifically, and I loved it. I did love the work, and that kind of inspired me to look for that sort of work in private practice. And so I did, criminal defense. The first jury trial that I actually tried, criminal case, was a murder trial.
Oh, wow.
Only like a year to 2 years out. And I tried a bunch of criminal cases, got some experience, and then I enjoyed criminal work, but you couldn't really make much money at it. So I got into Section 1983 cases, and I started out doing that in state court because that's what I knew how to do. And I realized that there were issues with that because there were just so many state-created defenses that it just really wasn't feasible in state court. And so I sought out a lawyer that was experienced in 1983 cases in particular, and he sort of showed me the ropes. And then I've been doing 1983 cases in federal court ever since. And people are interested in the topic, and just having those sorts of cases, you get kind of viral videos already. And I found myself in a position where I had this crazy video that I needed to release to the public like all at once. And so I created a YouTube channel, and that was my first video, and I had no idea what I was doing. I don't even think there was audio. It was just like the video footage, and then I put words on the screen. But it went viral, for a first video, so especially locally. And then that sort of, one thing led to another. And, then I ended up doing YouTube videos. And, here I am now, where I've been taking it seriously since, I don't know, maybe mid-2022. And 2023 was the first sort of full year where I consistently, worked on YouTube videos. And now that's basically my primary income is just being a content creator and also practicing law at the same time.
Yeah, I imagine that there's sometimes some tension between those things, which we'll get into later. But how did you and Patrick meet each other? Because you guys have worked on a case together, right? How did that come about?
Yeah, we first met working on Matt Gibson's case, involving the judge that searched my client's house, and that sort of played a partial role also in me having a YouTube channel. I think that was maybe the second or third sort of viral video that I had uploaded to my YouTube channel, and of course it was a crazy like scenario, but that went viral. And that's when I first realized, I think, the power of not just YouTube, but of viral video itself, especially in the context of law. That, I had already learned, so I'd practiced for, long enough at that point to understand sort of not the futility of civil rights lawsuits, but just the difficulty of them, and the fact that you really can only achieve very few results. I mean, you can get money mostly, and anything else that you achieve is just sort of is a coincidental byproduct. But whereas just one video, even if it's not something that's well produced, just raw footage can be extremely powerful and can get any results, and can take down powerful politicians or even judges. And so that sort of played a role in sort of what I ended up doing. And that's where I guess to answer your question, that's where I first met Patrick. And I don't know if I even knew what the Institute for Justice was before that. That may have been sort of my first introduction to the organization. And it may have been Matt, the client. And I really, as you guys know, he's fun to be around. I'm still friends with him. I still get texts from every once in a while. But I think he said, he's like, "Yo, dog." He's like, the Institute for Justice is interested in this case. Like, you gotta talk to them. And I think that's where I think that was maybe my first introduction to the Institute for Justice. And then it's like I realized very shortly, like, wow, this is awesome. This is like everything that I'm interested in, like that I've struggled to do here in my state, a very small level, just kind of fighting in the trenches. Like, here's a big, like, nationwide version of that, like, of everything that I'm interested in. And then I started looking at all these other cases that IJ was doing, and I instantly became, sort of a big fan, but especially getting to work that case with you guys. I've been a fan ever since.
Yeah, it was a great experience. And there's no question that John's spot on about the power that video provides in these cases, because, words on a page are only so illustrative. But in the modern era, if you can show people a video of the thing happening, then they can actually wrap their head around it. Because it's really easy, I think, for things like this to get swept under the rug. And the unique thing about Matt Gibson's case and many of the other cases that John's talked about on his YouTube channel is the things that happen are so outrageous in them that it's actually easy for regular people to hear the story and just have it go in one ear and out the other as like, well, that can't be right. Like, this guy can't possibly be characterizing things accurately. But if you pop the video up on the screen and you walk people through frame by frame, like, here's what is happening now, listen, he's going to say this and the judge is going to say that, then it's impossible for people to avoid. And I think, the one thing about that case and the importance of video that really stood out is when all was said and done, you had the Fourth Circuit affirming that this judge could not claim absolute immunity, which is incredibly rare. And the circuit was so focused on the fact that this judge had sat down in our client's chair and taken her shoes off and like kicked her feet up. It's like that image became kind of like the symbolism of this case and how the judge's behavior was so egregious.
Sure, yeah. So we've, sort of been talking around this a little bit, but for listeners who might not be familiar, can you kind of just really quickly walk us through what happened in Matt's case?
All right, here's what happened. This involves the family court of Raleigh County, West Virginia. So Matt Gibson had a divorce in that family court system, and the divorce ended. It was finalized, and a year later, his ex-wife brings him back to court and files, I think it was like a petition for contempt, alleging that he did not comply with the final order of divorce, which was an agreement. So they had an agreement down to like which DVDs would be distributed between husband and wife. And it was a contentious divorce. My client, or our client Matt, was represented by counsel in the original divorce case. It wasn't me. A year later, when this petition for contempt is filed, he's not represented by counsel. And so he appears at the hearing or hearings pro se. And there may have been multiple hearings, I don't recall, but he was going back and forth with his ex-wife's lawyer, who seemed to be pretty aggressive. Like, he was going after these DVDs that weren't fully turned over, family photos, but it was all pretty much little things. It wasn't like money in a bank account that wasn't turned over or anything like that. This was all items of personal property, that was alleged to be cooped up in Matt's home somewhere. So at the hearing where this culminated, like, they're in court at the family court, I don't know what they call it, at the courthouse in Beckley, West Virginia. And it's a nice one. It's actually a very large, by West Virginia standards, like courthouse, family court area. I mean, there's multiple family court judges there. They have, the facilities are very good. So this is has been a well-run, well-oiled family court jurisdiction. Okay. And this judge had been there for like 20 plus years. And everybody, it's like a place where everybody knows each other, and the lawyers that appear before this judge do so like every day. So everybody knows each other very well. And that's part of how those systems operate is, it depends who your lawyer is, because, do they get along with the other lawyer to make a deal? Do they get along with the judge? It's one of those things. So Matt comes into this hearing and he does not have a lawyer. So I think it was the night before the hearing, the ex-wife's lawyer calls Matt's phone because he's pro se. Matt doesn't answer, but he leaves a voicemail saying, if you want to avoid what's going to happen at court tomorrow, we'll accept $5,000, I think it was. And if you won't pay the $5,000, then we're going to go ahead with, try to hold you in contempt. Matt does not pay the $5,000. He proceeds with the hearing. And shortly into the hearing, this happens. The judge basically stops the hearing and says, Mr. Gibson, what's your address? We're going to go to your house. And he had no advance warning that was going to happen. He didn't know that was a thing.
Is that a thing? Like,
that's maybe the most remarkable part about this case. I remember when I first saw the video, until I saw the video, I thought, well, there's no way that this would actually, happen in a family court setting, as informal as those can sometimes be. But you said she'd been on the bench for 20 years. She asked for his address. They go to his house. Was this common for her? I mean, it sounds like she felt so comfortable that she just kind of did it of her own volition.
Yeah, this was not something, this was a thing in that particular county. Mm-hmm. This is not something that I had ever heard before. I wasn't aware of it because I wasn't in that area and I wasn't one of those lawyers that had been part of that system. But she had apparently been doing this for around 20 years. Mm. And so there was another family court judge that was in that same judicial circuit that he was doing them as well. But his excuse is that his predecessor, his colleague, the same judge, had been doing it. And that was basically, what he dealt with. That was what he knew when he was practicing law before he went on the bench. So it was, as far as I can tell, this was not happening anywhere else in the state of West Virginia. This was a thing that was just happening in this one particular county.
Yeah, so it was the custom of this county to regularly violate people's constitutional rights, as the West Virginia Supreme Court would later explain in upholding sanctions against this judge.
And as far as, I guess it depends on what your principles are. Like if your goal, or what your goals are, if your goal is to operate the most efficient and effective family court, the most efficient and effective family court-like system it worked great for them, because if one parent claims that, or if one spouse claims that their DVDs or their barbecue grill or their chainsaw is being hidden at the other spouse's house, then they just go there and search the house and find the items, and they enforce the final order of the divorce. I mean, it's an effective means of enforcing the final order. And that's what these judges complain about, is we can order all these different things that we have the power to order, but we have no way to enforce it most of the time. So here they found a way to enforce these final orders just by going to the property. And I think the judges and the lawyers, by all accounts, loved it.
Sure,
so it was great for all of them.
Yeah, but we have this system where you have, different branches of government, right?
Yeah.
So Matt objects to this at some point, right? What happens when he objects?
Right, and before we get to that, I'll note that when this went public, I was flooded with contacts from other people who had experienced this.
Oh, wow.
So while it was good for the judges and good for the lawyers, it was terrible for the litigants,
right.
For most of the litigants, especially pro se litigants. And I learned that kind of the way this worked, what they were doing was they were using the threat of these home visits or home searches as a sort of a sword to negotiate with. So it was like if you have any kind of family court dispute, the lawyer on one side would say, look, we are going to ask the judge just to go to the house and look. If you want to avoid that, you can write a check now for $5,000 or $500 or make this agreement that you don't otherwise want to make. And this even extended to people I talked to are like female domestic violence victims that now they're in family court. And this one particular woman I have in mind, she had a lawyer, and the lawyer was going along with this. And the threat was, if you don't agree, or if you don't, I think it was pay money. If you don't pay this amount of money to your ex-husband, we're going to ask the judge to go to your house, and your ex-husband is going to get to go to your house and go through your things. So this is somebody from an abusive relationship that was absolutely terrified of the ex-husband coming to her house, which was not, I don't think it was ever his house. And the prospect of that was so traumatizing that she just wrote out the check right then and there and made the deal that this other lawyer was demanding. And she had a lawyer that entire time that was okay with this, was not going to object to it. And the reason this came about with Matt was every other time that this had happened in this 20-year period, lawyers were all involved. So nobody objected to it. The person who had a judge visit their house was represented by counsel who had the opportunity to object to that and did not object. And so that was the way that this continued on for 20 years and never sort of surfaced where somebody outside that system was aware of it until Matt Gibson. Now, when it happened to Matt, it just so happened to be that he was pro se. And it wasn't that he couldn't afford a lawyer. It was that he was just kind of fed up with the whole process. He had to pay for this expensive lawyer the first go around, and he went through the whole divorce. And now, why should he have to pay out thousands of dollars more to hire a lawyer again over fighting over these DVDs? So that was sort of, I think, the reason why he didn't have a lawyer. But then he realized very quickly the problem with that is now, he doesn't know how the system operates. And so that also was the downfall of the judge in this system, is that all of a sudden, they're doing this to a pro se litigant who does not have a lawyer to consent to it or to just not object to it. And so when she says, what's your address? We'll be at your house in 10 minutes. Matt was savvy enough to know that that was not right. I mean, he is technically a federal law enforcement officer. He's been around the system, and he knows enough about basic constitutional rights that he knows that this is like a judge going to search his house. This can't be right. And in that 10 minutes, he comes up with a plan. And his plan was, when the judge gets there, he's going to film this. He's going to have witnesses. And then he is going to make a motion for the judge to recuse herself. And so that's what he did. I mean, had these stars not aligned, this would still be going on there.
Right. And like John said, the irony here is that Matt didn't know how the county system worked, but Matt did know how the constitutional system worked.
Right.
And as it turns out, those two things were in great conflict. And that was sort of what came to a head in this case, because Matt didn't understand how business was done in this county. And so he just challenged it because he knew, well, this doesn't sit right with me as a basic matter of constitutional principles. And that's what sort of brought us to his front yard, where he's now telling the judge, I move for your recusal. You're not going to go search my house. And the judge is saying, oh, yes, I will. And I think, from there, it just gets more illustrative of the problems that were going on.
Yeah, so he filmed, he had, I believe it was his girlfriend, just with his cell phone or her cell phone, just filming vertically him walking up to the judge as she arrives in his front yard. And he walks up to her and he says, I'd like to make a motion for you to recuse yourself. You're putting yourself in a witness capacity. And she's sort of taken aback, and she says, well, your motion is denied. And he's like, well, I want a warrant. You're not going to get in my house without a warrant. She says, oh, yes, I will, and threatens to arrest him multiple times. And then she forces him to turn off the video. But he anticipates this, so he's still recording audio from his pocket until he gets caught. So we have additional audio as this search begins, and he's threatened with arrest again. I believe a total of 7 or 8 times he's threatened with arrest. And finally, the bailiff there realizes that he's recording audio, and he's shut down from doing that. And then the search commenced. And then after the fact, I don't know how he got hooked up with me, but I remember meeting with him for the first time, and the story was kind of crazy. So it's like, yeah, he went to the top of the list of people like I wanted to meet with as soon as possible. And I'm like, what do you mean, like a judge searched your house?
Right.
And you have video of this? And I remember seeing the video for the first time, and I was just kind of like everybody else who even heard about it. Like, what? This is nuts. And had he not said what he said, acting like, had he not made a motion for the judge to recuse herself and demanded a warrant, I think the video would not have been as effective, because she clearly threatened to arrest him, and that sort of, helped make clear like what this was and was not. It wasn't just something casual where the judge and the parties are going to just to look at something that's, she made it clear that it was a court proceeding that was occurring in his front yard, like under threat of arrest, and he couldn't videotape it even in his own front yard. So when I first saw it, he's like, well, what do you think, man? He's like, this is a violation of my rights, right? And I was like, to be honest with you, Matt, like I've never seen anything like this. Like I don't know the answer to that, like the real answer, but it's got to be. It just has got to be. Like this is not right. And so I researched it and couldn't find anything like on point. And so I basically said, all right, Matt, let's just put it on the internet. Let's just put it on YouTube and let people see it. And so I think that's what we did. And I don't remember if I put it on Facebook, or I know I put it on YouTube, and it sort of went crazy. And within a couple of days, the TV news was calling, and that helped as well. So within just a couple of days, 2 different TV news stations met me and Matt in his front yard, and we did kind of a little press conference and explained to them what happened, showed them the video, and then demonstrated what happened, how the search occurred, walked through the house. And at least one of the TV news organizations ran the story. And I think the other was afraid.
Yeah.
And that sort of was always, that played a part here because people were afraid. They were afraid, and lawyers were afraid of calling out a judge. And so I wasn't afraid. I put it out there and I took a position from the very beginning. And you can even watch back that TV news segment where I said, I think I said, judges don't search homes. That's not what judges do. And that was the end result. That was litigated. That phrase, people disagreed with that, and that was litigated for several years.
Yeah. That was the winning theory of this case. Yeah. I mean, that was that simple. And so, John litigated this case and actually won it in the district court. And so when we got involved, we were just trying to defend this case on appeal in the Fourth Circuit. And to his point about not being able to find other cases like this, when we won this case, it was the fourth case ever decided in circuit courts that had said a judge acting in an executive capacity, like one searching a house, is not entitled to judicial immunity because they're not acting in a judicial role. So again, that's the judges don't search houses piece of this. And so that was absolutely right. That was the guiding principle here, and that is ultimately what the Fourth Circuit used to say to this judge, no, you can't hide behind your title and do whatever you want. And here, like I said, they said she took off her robe and she kicked up her feet, and that was very compelling. And so that kind of wraps up into one thing, how important the video is here and how important it is to just see something is wrong and fight for it because you have the same sense that Matt had, that John had, and that we all had when we saw what happened here, which was just this is crazy. Not in America. I mean, this is just not how things are done.
Did you know IJ represents ordinary people, free of charge, as they fight back against government abuse? If you're looking for a rewarding way to support our work, consider becoming a member of our merry band of monthly donors and stand shoulder to shoulder with IJ's clients every month of the year. Monthly donations are convenient and cost-efficient, meaning more of your money goes directly to our fight for freedom and justice. Sign up to donate today at ij.org/monthly.
Well, and speaking of the Fourth Circuit case, Patrick, when you took it up, did you get pushback or skepticism from any of the judges on the Fourth Circuit? Because one of the paradoxes of judicial immunity is that it's a doctrine that's created and governed by judges who are themselves, benefit from it. So did you get skepticism from the panel, or was it the kind of same, oh my goodness, I can't believe that this is how it happened?
I think at least two judges on the panel were extremely in the oh my goodness category, which was good. And a third was kind of skeptical about maybe things that were not relevant to this case that could potentially have been relevant in other circumstances. But I think on the whole, it was still very shocking for them as judges to imagine themselves being in a situation like that. And so I think that can help sometimes. You obviously have the bias of judges deciding what kind of immunity judges should have.
Right.
But I think the flip side of it is you also have judges who probably take very seriously their role and just try to imagine putting themselves in the same shoes as another judge doing crazy things and thinking I would never do that. And so it can't have been the thing a judge would do because I'm a judge.
Right.
Yeah. Yeah. And of course, this is a dynamic you see a lot, which is well, trust us to report on ourselves whether we're doing bad things, but don't, look behind the curtain at the man who's back there running the Oz machine. And so that's the importance of this video. And it's hard to imagine if this case had no audio or video recording of any type, that it would have definitely come out the same way. I mean, I'd like to think that it would have, but I'm not, in my heart of hearts, sure that that's true.
And this kind of goes back to our original discussion, right? What has been the impact of video on civil rights law? Because you can imagine these sorts of cases being brought 20 and 30 years ago, and they were, but they were brought before smartphones. And so nobody had video of the encounter. And ultimately, in a lot of those cases, it's a he said, she said sort of a thing. And so no one really knows who wins or loses. And oftentimes in those situations, the extraordinary is rejected as being sort of improbable. Do you both kind of take the same view, that video recording and the proliferation of smartphones has kind of revolutionized civil rights law in the country?
Yeah, absolutely. And, I had one of the only cases I've ever heard of a federal judge throwing out a jury verdict in a 1983 case on behalf of the plaintiff. And I had that experience where I tried an excessive force case, and there was video. And you could see this took place in Parkersburg, West Virginia, in a holding sense, like a processing room, where they take the handcuffs off and they do the fingerprints and all that. Well, an officer had taken my client's handcuffs off and then basically challenged him to a fight, kind of. And there was no audio, but there was video, just the video, and you could see that the officer basically punched him right in the face. And the guy, it wasn't in response to a threat, but it was in response to just this verbal exchange that they were having. So we had a jury trial over it, and the officers are testifying, and there were 3 officers in the room, and they were all testifying like, oh, no, I didn't see a punch. I didn't see a punch. Did you see a punch? No, I didn't see a punch. It was, you may have seen like a pressure point. Sometimes we do that right behind the ear. And it was that sort of thing. And the jury had seen the video. But at the same time, my client had tattoos on his hands and his neck, and was not like a ideal role model plaintiff, as many times are not. And the jury comes back with a defense verdict. And the judge is, after the fact, he's just sort of beside himself, and he's like, I don't remember if I brought it up or the judge brought it up, but he's like, all right, if anyone has any post-trial motions, I very seriously may entertain some post-trial motions. So I filed a post-trial, I can't remember what the name of it is, but a motion to throw out the jury verdict. And so the judge did. He threw out the defense verdict and then granted judgment as a matter of law for the plaintiff in a 1983 case, and then ordered a subsequent trial to be held just on the issue of damages. So it was a fantastic order. And in the order, he discusses the footage, and he says it reminded him of the Groucho Marx scene where, they say, who you gonna, where Groucho has the fake nose and the fake glasses on, and he's pretending he's somebody else, and he says, who you gonna believe, me or your lying eyes? So the judge actually wrote that into the order, and he also mentioned Rodney King. That it doesn't matter what the verdict is if the video shows something else and the public sees it. And so the judge threw that verdict out, and the defense went crazy, and they appealed it to the Fourth Circuit, and we had oral arguments at the Fourth Circuit and won there. And it's in some law, that case is still in some law school textbooks on the issue that if you have video footage of police officers committing a civil rights violation, a court is free to disregard contradictory testimony, testimony by the officers that's clearly contradicted by the video. And that's based off a U.S. Supreme Court case called Scott versus Harris. But it was applied to that sort of scenario, and was used to throw out that defense verdict. So had that not been on video, there's no way that ever would have happened. And that was sort of early on, before there was body cam. And now, every case has body cam, and I wouldn't take a case without body cam. And that just happened to be a surveillance camera.
Yeah, I think the thing to keep in mind too is there's no question in my mind that it's absolutely the case that this has brought to light a lot of things that otherwise would have been swept under the rug. But it's also not been a panacea. And I think the other thing to keep in mind is that it shows because plenty of people kind of on the other side, so to speak, will say, oh, well, a lot of these cases are made up. And that's yes, the video is great because it shows both sides of the story, ideally. We can see situations where people have claimed things happened to them, and then it turns out that those things didn't happen to them. In fact, Scott versus Harris was a case like that, where the plaintiff's position was contradicted blatantly by the video, which is what caused the Supreme Court to state that principle. But at the same time, Keith and I have seen Scott versus Harris go the other way, where the appellate courts kind of get to just say well, we don't really care about the facts in this case because we watched the video, and so we get to decide. And so there are problems that are created by the same principles. But I think in the main, it's important and it's very valuable to have everyone walking around with video cameras in their pockets. So the kind of spate of state laws that have been passed in the last couple of years that are restricting people from filming within 25 feet of police or things like that are actually bad for both the public and the police, in my estimation.
Yeah. Shifting gears a little bit, you've talked about the videos that you've posted, the public attention that gets, the media attention, things like that. IJ filed recently a case about a civil rights attorney who was slapped with a gag order because he was talking about his case publicly. So I imagine you have feelings about that. How does that, resonate with you?
I've had similar concern, and it's been sort of in my, and I only practice in West Virginia federal courts, but, we have 2 federal districts, and I practice in both of them. So I practice all over the state of West Virginia, and in almost every case, like, I'm sort of a lawyer of first impression. Like, I don't think there was anyone before me that was litigating those sorts of cases and then also, like, had a YouTube channel and was capable of, showing it to the public directly, especially on a nationwide level. And so, there are no, like, orders or case law governing the situation when the defense lawyers object. So that, that has popped up, like, in my practice, where they constantly are threatening to run to the judge to try to, get a gag order or protective order to stop me from, posting anything about the case or commenting on the case. And, it's my diehard belief that is unconstitutional, like, on every level. And the only thing that they have going for them in that argument is, well, the judge has the ability to control pretrial publicity, just part of ensuring a fair trial, which is ridiculous for the most part, because, the videos that I do are, shown to a national audience. And I've even presented, when this has come up before, like, statistics, from YouTube showing that the large majority of people who watched a specific video that they were concerned about, like, were in California.
Right.
They weren't in whatever county in West Virginia. And I was able to narrow it. There was, like, just a few thousand people, like, in West Virginia that even watched that video. Like, the statistics, or not the statistics, the
like, demographic.
They're that specific where you can see exactly who, so they're trying to stop me from discussing to people all over the country, what's happening in one particular case, just because there may be, just theoretically, somebody who might end up on a jury in that particular jurisdiction. I mean, it's not a rational argument at all, especially when, they allow the law enforcement agencies to post things on their social media. They allow them to post mugshots and allegations. They allow all sorts of TV news stories.
Sure, that seems to me to be the most obvious egregious point on the other side, is, like, when they make an arrest, that's all public. The pictures of people getting arrested, those are public. They hold press conferences, those are public. And most of the time, outside of an institution like IJ, or maybe John, now that he has the prominence, the news media is going to take what the government said about the case and reprint it. They're not as likely to take that position from the plaintiff's attorneys.
And then they're never going to do an update video on what actually happened. So you have the initial story blasted out there with the allegations that were completely unproven, and then no follow-up story.
Right. The perp walk is a thing, This is done by design by the government in these cases to impose, some form of punishment. And so it's sort of beggars belief for the government to then turn around and say, oh, well, but you're not allowed to talk about this case. You're not allowed to comment on this case to the public, even though this is a case involving the public interest. And so that's sort of the frustration, in the scenarios that John's describing, and of course in the case that IJ is litigating right now.
But I think I've only had one judge so far basically issue a protective order. And here's what it said. That Mr. Bryan's not to upload anything to YouTube or anywhere else until the trial has occurred. And once it has occurred, then must come back to the court for basically release or permission
Wow.
to release the footage. So that's the only time I've had that happen. but that sort of discouraged me enough to not bother with it, which is a shame, because then you have people who aren't as informed on issues of public interest as they should be. And that's my position, is that these things are all items of public interest that for many years have been suppressed by the government. And it's like when a police officer engages in some sort of outrageous act of misconduct that is so bad that the state yanks his certification to even be a police officer. The sad reality of the current state of law in my state is that most of that is all confidential, like employment-related confidential information.
Right.
And that's true in a lot of other states too. And there are special contracts that are entered into between union lawyers and government entities that kind of sweep all this under the rug permanently. And I think the other thing that sort of shows how silly all this is we live in a system that's supposed to have our courts open to the public, and so restricting something that John or any other attorney in their own case can say for the sake of the public interest is hard to square with the fact that you have, for instance, dozens of other YouTubers who aren't lawyers or who are lawyers that aren't talking about their own cases, and they're able to, rightly so, talk about these issues, comment on them, publicize the video of things that happen, because we want the public to be able to know these things are happening and then discuss them. And if you go into the comments, oftentimes you'll see people having arguments there. So it's not necessarily the case that showing these videos will inherently be beneficial to the plaintiff or the defendant in any given case. But what's important and why we have the First Amendment is so this information can be made public and discussed. And so regardless of any, sort of pretense of the importance of not prejudicing juries, courts can work around those things. Courts can enter protective orders in such a way that will say, well, if you're doing this in a way that would prejudice a jury, you can't do that. But otherwise, you should be able to talk about this stuff. That's what the First Amendment guarantees to everybody. And it's important from both the perspective of the speaker and the perspective of someone who'd like to hear the information.
So, John, what struck me today, hearing you talk about your experience both as a lawyer and as a YouTuber, is, your strategy in launching cases. I'm thinking back now to the press conference that you had in your client's front yard in the judicial field trip case before IJ ever got involved. That sounds so similar to how we at IJ litigate cases. We're always talking about trying to win cases, not just in court, but in the court of public opinion. And it sounds like that you have kind of independently developed similar strategies that we use to further your own practice. And I was just kind of curious, in this day and age, with media as prevalent as it is, how do you think that the sort of videos that you're doing or the press conferences that you're hosting, how is that impacting your client, and how is it impacting more broadly the practice of law? Because I think a lot of old school lawyers often get upset at IJ, and I'm sure you've experienced some of that ire too. You're not supposed to be arguing your cases to the public. It's the court that matters. But I think the tides are changing, and I'm curious as a non-IJer, how you view that happening.
Lawsuits are they're great, but they're just ineffective. The government does not care because of the current regime of qualified immunity, and they're just not afraid of it. And so they are absolutely afraid of public exposure. And so it's allowed me to basically, I think, stand up to bullies across the country, and government can be the worst of the bullies. And I think where I was going with this is that there's such an untapped market out there. And that's not the right word for it, but there's such a large segment of the population that feels that they have no say in things. They feel powerless, that the government is, and the police in particular, they don't trust them, and they have nobody to go to. I get calls every day from people who think that I'm like the attorney general of the country. They're like, this happened, what are you going to do about it? And so that tells me that they have nobody that they can go to. You can call the Department of Justice tip line, but you'll never hear back. And so people are like crying out for a way to help. And that's also, I think, why IJ is so important, is because when people call from all over the country, if they're not from my state, we send them directly to the Institute for Justice, because where else can they turn? There's really nowhere else. It's a huge demand of people who feel like government's violating their civil rights, and they probably are, and just a very small supply of anyone who can help them. And so they're crying out for help, for legal help, but also just to expose what's happening to anyone who will listen.
Patrick, can you talk about kind of the flip side of that, of like the spotlight that John is shining on things helps us too on our side of the litigation, right?
Yeah, absolutely. I mean, not only do you have, John shining a light on things, but you have his audience realizing, oh, IJ is a good place that is making some of these inroads. And I think the flip side of the situation right now, where people do feel like helpless and incapable of making a change, is that's exactly why the changes need to be made. It's because we don't want people feeling so disconnected from the government that they can't trust what the government's doing. And so making the law better is actually beneficial to everyone, because then people do have this restored sense of, okay, I have some sense of trust in these institutions, and I know that if things go wrong, there'll be a way to hold people accountable. And so, through the Project on Immunity and Accountability, knocking down the obstacles like qualified immunity, like judicial immunity, is so important, because then it opens up the category of people who can do something when things go wrong. And the hope was always, through the project, that we would be able to knock down these hurdles so that, regular lawyers across the country who don't have an expertise in immunity doctrines and Section 1983 and Bivens causes of actions and so on and so forth, will be able to just take cases to court and say, something's wrong here. Let's have a jury decide whether, this happened or that happened, and then we can all go along our merry way. And that way everyone feels like there's a system that's responsive to what they view as grievances. And, maybe they'll go in and lose, but at least they got to have their day in court. And the thing that's being denied right now through many of these doctrines is that, the day in court. And so having people like John shine a light on this, sending more people to the Institute for Justice for us to try to litigate these issues across the country, is all sort of aimed at getting back to the sense of, I have a right, therefore I'm going to have a remedy. And even if I go to court and the jury ultimately sides the other way, at least I got my opportunity to say my piece.
And Kim, I know you approach this from a development perspective. Many of John's viewers have actually become IJ donors. Do we have hard numbers on that?
Yeah, we've gotten more than 1,000 donations that have been generated by John's channel, and they total more than $62,000.
Wow.
So John does great work on the litigation side and on the media side, and also as a honorary development fundraiser for IJ. We really appreciate all of the work that you do.
Well, good. That makes me feel good.
Well, thanks so much for coming in and for the incredible work that you do. And it was great to talk with both of you today.
Yeah, well, thanks for having me. I'd like to do it again.
Sure.
Absolutely. That's it for today. Thanks again for watching, and don't forget to subscribe.